Thank you, Nicola, and thank you for having me here today. Maybe I shall say just a few words about Client Earth, the NGO I work for. It's an environmental NGO which has a specificity, which is that it's almost exclusively composed of lawyers. Given the lack of lawyers working for the NGO community, we thought there was a need for more legal expertise within the environmental NGO community in Europe. So we are based in London, in Brussels, and in Warsaw. I'm based in Brussels, and we work with the European institutions, and I work more particularly on the implementation of the Aarhus Convention, which I will tell you a bit about today. So I'd like to speak, it's not related to climate or to the Volkswagen scandal, but in a way it is related because it's about transparency. And so maybe if there was more transparency in these processes, we wouldn't be in this situation today. So transparency or lack of transparency within the legislative process at EU level. Of course, we cannot talk about access to environmental information and transparency in environmental matters without talking about the Aarhus Convention. The Aarhus Convention is an international convention that provides the public with the right to have access to environmental information, to participate in the decision-making process, and to have access to justice in environmental matters, meaning having the right to challenge the decisions of public authorities before the courts and also before administrative procedures. The Aarhus Convention has been ratified by the EU in 2005, which means that it is legally binding on the European institutions, the agencies and the bodies, as well as on all the member states in the EU and on all of the public authorities in these member states. It's been described as one of the most ambitious environmental agreements precisely because it gives the public these procedural rights to ensure, eventually, a better protection of the environment. Unfortunately, it's only partially implemented and even transposed at EU level. As you may know, the two first pillars, the one on access to information and the one on public participation, has been implemented through directives. Directive 203/4 on access to information, and another directive amending the EIA directive and the IPPC directive to ensure public participation and access to justice within these processes. Unfortunately, the third pillar of the Aarhus Convention still hasn't been implemented at EU level, the access to justice one. No directive on this matter. And the result is that the access to justice rights is not equally implemented throughout the EU. You have issues with the cost on access to justice in the UK, really prohibitive cost if you lose a case before the court in breach of Article 9.4 of the Aarhus Convention. You have issues in Germany with regard to legal standing before the court for NGOs as well. And you have other states like France, which is where access to justice is provided with less problems. So really unequal implementation of the access to justice rights as provided by the Aarhus Convention because there is still no directive adopted to implement these rights. Unfortunately, now I think it's almost official that there won't be a directive and that there may be a non-legally binding instrument implementing these rights, which of course means that non-legally binding instruments put much less pressures on the member states to comply with the provisions of the Aarhus Convention, unfortunately. In 2003, the Commission had adopted a legislative proposal that had been stalled in the Council, so because of the opposition of the member states, and since then, nothing happened. But today, I will focus more on the access to information pillar, and more generally on transparency and the lack of transparency at EU level. So First, why talking about access to documents? Why does it matter? Well, because freedom of information and transparency are really fundamental values in a democratic society. That's actually what makes a society democratic. And the right to access information that is held by public authorities or by the European institutions is a precondition to participation in the policy-making process, and also to the adoption of sound decision-making in environmental matters. Unfortunately, there is today a lack of transparency, and there are threats to the existing rights of access to information. For example, if you look at the Commission's proposal when the Regulation 1049 on access to documents held by European institutions was being reviewed, the main provisions in the proposal were aiming at really increasing confidentiality of the decision-making process and making less documents publicly accessible, supported by the Council and the Member States. So there are really threats to existing access rights. And that's why civil society actors play a really, really important role in consistently exercising their rights to access to documents to eventually promote a better institutional behavior. There are some justification in the Convention's preamble on why access to information matters for the environment. One of them is that every person has the right to live in an environment adequate to his or her health and well-being, and to be able to exercise this right, they need to have access to information and to be able to participate. Also, increased access to information increase accountability of the decision-making makers and furthers the public support for decisions on the environment. So that's why it matters. There are, of course, provisions in the EU treaties. I won't go through all of them. That says that European institutions need to act as openly as possible and as closely as possible to the citizen to ensure the participation of civil society and that its proceedings are transparent. The treaty also provides a right to the citizens of access to documents. Also, of course, the Aarhus Convention is implemented through the Aarhus Regulation to apply to the European institutions, agencies, and bodies as well. And the Aarhus Convention prevails over both these regulations. Now, more specifically, what about access to documents within the legislative process? Sorry. There is a special status for the legislative documents recognized by Article 12, Paragraph 2 of the Regulation 1049 that states that, in particular, legislative documents, that is to say documents that are drawn up, but also received by the European institutions in the course of procedures, legislative procedures, to adopt legally binding acts, should be made directly accessible. So, special status for legislative documents. The Court of Justice has also stressed the need for more transparency within the adoption of EU directives and regulation. For example, in the Turco case, but we could also quote the Access to Info Europe case. And what did the court say? It said, openness contributes to strengthening democracy by enabling citizens to scrutinize all the information which has formed the basis of a legislative act, and that citizens have the opportunity to find out the consideration underpinning legislative action is a precondition for the effective exercise of their democratic rights. So even the Court of Justice really confirmed the importance of having a transparent legislative making process. The Access Info Europe case, in this case, the court has refused the arguments from the Council that didn't want to provide access to the different positions of the member states in Brussels discussing the adoption of a law. The court said, no, you cannot do that. You're in Brussels, you're representing elected governments. Your positions need to be made publicly accessible, and the names of the states cannot be redacted from the minutes of the council working parties. So that's really important when you think about it, because I think we're all familiar with the arguments at national level from the governments that everything comes from Brussels. It's Brussels that is imposing this new legislation, this new regulation, and etc. Well, in fact, governments are in Brussels as well, and of course participate in the adoption of the EU directives and regulation. So that's a fact, and that's why we need increased transparency on these discussions that are taking place between the member states when they adopt EU law. Having said that, I'd like to look at the different stages in the legislative process at EU level and see where it's transparent and where increased transparency should be made. First, the stage of the impact assessment adopted by the European Commission. As you know, the Commission does an impact assessment before adopting legislation or a policy decision. It's described by the UN Commission's guideline as a process that prepares evidence for political decision makers on the advantages and disadvantages of policy options by assessing their potential impacts. And it's a key element in the development of the Commission's proposal. So the Commission recognized that it's really a key element. It's going to be taken into account by the College of Commissioners when they are going to adopt a legislative proposal. Yet, you will see that these documents are kept confidential until the adoption of the legislative proposal. An NGO, Client Earth, wanted to have access to two impact assessments, one related to the implementation of this famous access to justice pillar of the Aarhus Convention, and wanted to know what the Commission was doing, whether they were considering adopting a legislative proposal or a non-legally binding instrument, and what was the tenet of the discussion within the Commission on the way the access to justice pillar should be implemented. We asked for this impact assessment, as well as the impact assessment on the review of the legal framework on environmental inspections and surveillance at national level. And these two documents were refused, and the argument was that disclosure would seriously undermine the protection of the internal decision-making process of the Commission, so relied on Article 4.3 of the Regulation on Access to Documents, and that there was no overriding public interest in disclosure. So what did the General Court said? Unfortunately, it agrees with the Commission and set up a presumption of confidentiality along its case law on this presumption of confidentiality, which has been set up in competition and state aid and infringement context. And so it extended the scope of application of this presumption of confidentiality to impact assessments, and relied on Article 17 of the Treaty on the EU, which says that the Commission shall promote the general interest of the EU in taking the appropriate initiatives, notably the legislative action. And to do that needs to be completely independent. So in fact, the General Court ruled that for the Commission to be independent, it actually should act in confidentiality. And went on to say that the Commission must be placed in a position to act at the stage of the impact assessment in a fully independent manner to serve the general interest and free from external pressure or third-party influence which would attempt to compel the Commission to adopt, change, or abandon its policy option, and because also it would complicate the discussion taking place within that institution. So debate, discussion, transparency, public participation complicate the discussion at this level, according to the General Court. It also held that disclosure would seriously undermine the decision-making process of the Commission, and no higher public interest in disclosure exists, so all the arguments that Client Earth could make to show that the presumption should be reversed because there was a public interest in disclosure were all rejected. So the need to have a transparent and accountable process in environmental matters, the interest of an environmental NGO to know what the Commission is considering doing to implement the access to justice pillar of the Aarhus Convention, all these arguments have been rejected as not relevant. So there is a pending appeal. Some of the arguments made are that the General Court actually confused independence with confidentiality. And actually, the Court of Justice clearly indicated in other cases the contrary. You take the Turco case, the Access Info Europe case, the Court of Justice clearly indicated that the institutions do not need to act in confidentiality to remain independent. In the Turco case, the court said really clearly, if there is a risk of external pressure, undue external pressure on the Council, then it is to the Council to put a stop to that pressure. It's not the other way around. It's not because there is a risk of pressure that then the information should be made confidential, that then there shouldn't be transparency and public participation anymore. So there is a confusion here between independence and confidentiality. And we think that it's more transparency that allows independence and prevents external pressure than confidentiality, because let's face it, lobbying in Brussels is no secret, and it happens also when the process is confidential. Another argument made here is that what happens when no decision is made by the European Commission, as in this case? For years, impact assessment has been ready for years. We still don't have access to it. The citizens have been kept in the dark since 2003 on the way this access to justice pillar will be implemented. And because the Commission is not adopting a decision, the impact assessment is not disclosed, even if it's ready and finalized. So there is a lacune in this ruling, and of course that's the problem with regard to transparency and accountability. It is argued as well that the General Court failed to recognize that the adoption of this general presumption results in a non-rebuttal presumption, since all the arguments that the applicant can make to try and reverse that presumption are all rejected. So in fact, it becomes a non-rebuttal presumption, which is clearly in breach of the Aarhus Convention and with Regulation 1049 and with the case law of the court itself. Second argument was also the failure to recognize the existence of an overriding public interest in these documents in environmental matters. The public should have the right to know why the access to justice pillar of the Aarhus Convention is still not implemented, what the Commission is considering doing, when and how. So, of course, there is an overriding public interest according to Client Earth. Once the impact assessment is done, it goes to the European Parliament. And then the European Parliament must adopt its first reading position. And for that, an MEP, a member of the European Parliament, is nominated to adopt a report, its amendments to the legislative proposal. That's public, so that is good. There is an opportunity to discuss, to comment. However, then there are the shadow meetings. Shadow meetings composed of shadow rapporteurs, which are the MEPs representing the different political groups in the European Parliament. And this is a really important stage, since that's when this member of the European Parliament are going to adopt their compromise amendments to the legislative proposal, which are going to be voted upon in the standing committee and then in plenary. However, it's completely opaque, completely confidential. You don't have access to the minutes of these meetings. You don't have access to the discussions that are taking place between these MEPs, which are MEPs that have been elected by the public. And that should give account to the people that have elected them. Again, it's the question of Brussels and national level. The MEP that we elect during the legislative elections act in Brussels without being accountable. The reply that we get is that it's discretionary. So it's to the MEPs to decide whether they adopt minutes of these meetings and whether they provide access to these minutes. Completely discretionary. So, of course, a lack of accountability and a lack and a risk that the environment is not really taken into account in these discussions. For example, we were working on the adoption of the directive on the protection of trade secrets that is being discussed in Brussels now. These shadow rapporteurs, during their shadow meetings, discussed the definition of a trade secret. What type of information can the industry qualify as a trade secret? Environmental information, information on the impacts of their product on public health. What exceptions should be allowed for the industry to be able to sue whistleblowers, journalists, public that think that certain trade secrets should be made publicly accessible? What are the positions that these MEPs adopt in these meetings, and what compromise do they make? That's not publicly accessible. And then, once the shadows rapporteurs have adopted their report, normally it should be voted upon in plenary, except that these last years, that's not the case anymore in more of the legislative processes. Now we have what we call in Brussels trilogue meetings. Trilogue meetings are meetings composed of the Commission, the European Parliament, and the Council, few representatives only, of course, that meet to agree on the final compromise text, which will be the final text of the actual directive or regulation. These meetings are completely confidential, opaque. You don't have access to the minutes of the meetings. Again, you don't know what's being discussed and what the positions are of the different member states, of the Commission, what role the Commission still plays, and of the different MEPs. So we can ask the question, what is the legitimacy of these meetings? Because if you read the treaty, Article 294, paragraph 3, states that it's the European Parliament normally that shall adopt its first reading position and then communicate it to the Council. Then the Council either approves the European Parliament position and the text is adopted, or does not agree with the European Parliament's position and then shall adopt its first reading position and send it back to the European Parliament. And what's the value of this provision and of this process? Well, it's that there is a real public debate within the European Parliament, among the different MEPs, among the different political parties, in public, since Article 15, paragraph 2 of the treaty specifies that the European Parliament and the Council shall meet in public when considering and voting on a draft legislative act. So it's transparency, it's giving the right to the public to know what is being discussed, to know who says what state says what in Brussels, what MEPs says what in Brussels when they're there. And so that's the value of that. And trilogue meetings has unfortunately hijacked this debate for MEPs, because now not all the MEPs can be really involved in this debate, since these trilogue meetings only comprise a handful of MEPs and of the public. Yet, these reports, normally the minutes of the trilogue meetings are legislative documents under Article 12, paragraph 2 of the Regulation 1049. So they should have a special status and they should be made publicly accessible. According to the case law of the court as well, Turco and Access Info Europe, legislative process increase transparency because it's important that the public knows all the considerations underpinning the adoption of a legislative act. And surprisingly enough, the European Parliament adopted a resolution in 2014 calling the European Parliament, the Council, and the Commission for more transparency within informal trilogues by holding the meetings in public, publishing documentation, including calendars, agendas, minutes, documents examined, amendments, decisions taken, information on member states' delegation and their positions, and minutes in a standardized and easy accessible online environment. That's a great resolution. Unfortunately, it's not implemented. So we can argue that the refusal to provide information on these discussions is a misapplication of Article 4.3 of Regulation 1049. And unfortunately, all this information, it's cynical enough that everything is made public once the directive is adopted. So at least you have access to this information and to know what has been discussed and etc. But it's a posteriori. So it's too late to participate, to support, to oppose, to contradict, to provide evidence that goes in a certain direction. The issue of trilogues has become so important that even the European Ombudsman has decided to open a non-initiative inquiry on the way these meetings are organized and on the lack of transparency within these trilogues meetings. So she sent a series of questions to the three institutions asking how they were organized, the type of documentations that they used, who attended, because there is a problem with attendance in Brussels as well. Unfortunately, sometimes it's only the assistants of the MEPs that attend really important meetings. Not all the MEPs attend really important meetings either, and etc. A whole set of questions on the way these meetings were organized, and another set of questions on the information that was made available. The three institutions replied in a quite aggressive way, refusing the competence of the European Ombudsman to investigate on the way the trilogues meetings are organized. They invoked their discretion, their discretionary power in the organization of the legislative process at EU level. They invoked their political responsibility, so said that this organization fell under the remit of their political responsibility and that therefore, since it was political, it couldn't constitute a maladministration that is being investigated by the European Ombudsman. Procedural autonomy and the principle of institutional balance between the different European institutions. So really strong reply and reluctance from the three European institutions to even only accept that the European Ombudsman looks at the way these meetings are organized. Unfortunately, the part on transparency has been accepted. There are simply no grounds on which they could refuse. And so now we need to wait and to see what the European Ombudsman will say, whether she will adopt recommendation, critical remarks, or on the way these trilogues meetings are not made public and confidential. She also organized a public consultation that anybody can participate on trilogues meetings, and so now we just need to wait and see what she will decide. But so all that to say that there is still a need for increased transparency in the legislative process at the EU level, all that to ensure that the environment is taken into account properly. And also, since I know that there are lots of people working for ministries, just the message would be to remember that according to the Aarhus Convention, the public authorities hold the environmental information in the public interest. And so that's really important, I think, to remember. Thank you.